Thanks, John. I hope everyone can hear me okay, and the slides are now on the screen. I am a partner at the law firm of Holland Knight in New York with a focus on tech and data matters, especially in regard to cybersecurity and data privacy. I'm also a board member of the New York Metro InfraGard Association. And it is a pleasure to be presenting a webinar here for the New York Metro Joint Cybersecurity Conference. I know the title here is a bit of a mouthful, and we will certainly break it down. I will also try to not get into the weeds on the legal side of things and really talk about some of the kind of forefront issues that many companies are trying to deal with when it comes to vulnerabilities, but not just in the classic, defensive ways, but, what do you do? What new strategies for detecting issues, new strategies for responding to issues? Do you share data? Do you not share data? Who do you share it with and why? And thinking through those issues, not really from a legal perspective, but more from a strategic thoughtful process, and what are the business, operational, reputational, and to some degree legal implications of these activities. And many businesses are being forced to make a judgment call, and sometimes in the heat of the moment, and are looking for people within and outside the organization to help them understand what are the issues. Brief management, help senior management make very important decisions around these issues. And so we're going to jump right into it. I'm going to break it down into three buckets, so to speak. One is talking a little bit about bug bounty programs and what are the pros and cons and how they work and what are the pitfalls. Another topic that's somewhat related is around vulnerability disclosures and information sharing, and how that is done. And finally, talk a little bit about, dealing with stolen data or disclosing stolen data. Many of us know that there's a lot of data floating around on the internet, either on the clear web, on the dark web, in various, underground, criminal markets. And so thinking about that and what you could or can't do and what are the risks in dealing with that data, given that many companies have legitimate, reasons to be dealing with it. So to get started off, I've tried to create, we can call this a simple example, but this is really a bit of an ecosystem around disclosures. And so, I didn't want to put actual company names on the slide, but you can think about, a classic social media or online tech company that we can call InstaFriends here. Many of you, right away will come to mind some other companies and similar scenarios in real life. And they deal with, a lot of technical risks and security risks to their platform in many different ways. And so just to start out and talk about who the different players are here, right? They may hire their own penetration testers, either, inside the company. They may have a team that does that. They may have an outside consultant who provides penetration testing services, and they use them to test their app, to test their website, to test their network, periodically, maybe every quarter, maybe once a year, maybe more often, hopefully, for a big platform. They may also engage with a bug bounty organization that kind of helps them interact with, freelance hackers. And so, there are a number of them. The popular programs are BugCrowd and HackerOne, but for purposes of our scenario, we'll call this organization HackerFriends. And they're the ones who interact with, the good hackers, the white hats as they're known, who operate, legitimately and above board. On the other side of the screen, we see at the bottom the black hats, which are typically the folks, the hackers around the world who engaged in criminal activity, unlawful hacking activity, and of course, as many know, there are many individuals who operate somewhat in a spectrum between the white hats and the black hats. They're often known as the gray hats. So there are people that sometimes are engaging in legitimate activity or in unlawful activity, and sometimes they're engaging in activity that is questionable under the law. And I'll talk a little bit about that without getting too much into the weeds. But some of the other players here are obviously the FBI, Department of Justice, in terms of enforcing the law and prosecuting criminals. The DHS and the U.S. CERT might operate as a warehouse, a clearinghouse of vulnerability information and disclosures. And there may be information sharing organizations. So, for example, the quote IT ISAC in this scenario would be a industry consortium that operates to share information. And we're going to talk about different examples in reference back to this idea. So let's talk a little bit about the bug bounty ecosystem on the left side of the screen between InstaFriends and HackerFriend and the white hats and what that entails. So a bug bounty program, it encourages security researchers, in other words, white hat hackers, to report security issues to the sponsoring organization in a responsible way. And so even the government has operated a number of different bug bounty programs. They had one called Hack the Pentagon, and they try to provide certain incentives for responsible behavior. And so those incentives might be, they don't want the disclosure made public immediately, because if there are vulnerabilities and issues, the sponsoring organization wants an opportunity to fix it before the issue is made public. They also will reward the researchers who find issues with money or recognition or swag, T-shirts and coffee mugs and other things, maybe an invitation to their company's conference, sometimes even expenses paid, let them give a presentation on their findings. And so, different incentives can be created under these bug bounty programs to encourage this responsible behavior. And what's really phenomenal for a bug bounty program, and what distinguishes it from the classic penetration testing scenario, is that penetration testers can find something or they cannot find something. You can spend a lot of money and they don't find things. Really, with a bug bounty program, you're only paying for results. So the people who find things and they report them, they can get some kind of payday or reward. People might spend 6 weeks looking into your website or investigating your platform, they find nothing and they don't get paid. So from the organization's perspective, you're paying for results, and that's very cost effective. So let's talk a little bit about some of the pros and cons here. The pros are, even with penetration testers or internal information security teams, it's really very hard for them to catch everything. And I think about this as being, if you think about a house, how can you guarantee that an ant or a bug will never get into the house, right? I mean, things change every day. People open and close windows and doors, and the foundation, which may have been perfect when the house was built, over time deteriorates. New conditions change, pipes crack, things leak, and so this is such an evolving system that the internal or the pen testers will virtually never catch everything. And so the bug bounties provide you with another means to find things. You get access to hundreds or thousands of researchers, and you give them a profitable outlet. There are many researchers overseas that have supported themselves by legitimate lawful hacking, and they may be based in India or elsewhere in Asia or other countries, and they make a good living legitimately finding security issues and responsibly reporting it and getting paid. And perhaps they would be doing this illegitimately if they didn't have an avenue for this. And you think about it almost like the Napster days, with people downloading media, music and videos illegally, there wasn't really a lawful digital way of getting that kind of content. Now, that we do have those legal means, the amount of unlawful activity has gone, not that it's gone to zero, but certainly many people who wanted to act lawfully have an opportunity and a means to do that. And again, you're paying for results, and you have some control over the disclosure, when it happens, who it happens to, what information gets shared. Obviously, there are some cons to a bug bounty program. They're not your employees. They don't work for you. You have limited control over them. Certainly, people who start out operating in a bug bounty environment can ultimately attempt to, commit extortion or exploit the company and use their findings in a way that is not appreciated. Disenchanted researchers can go public if they feel the company is not giving them enough attention or enough money or otherwise keeping them happy. And so, bug bounty programs are not, the perfect solution, but they are one of the solutions, that many companies have found increasingly is necessary to help shore up their security posture. And bug bounty programs, there's no bug bounty law. So really there's this contractual ecosystem that companies open their bug bounty programs into. And there are many different documents, and this is where the legalese can become really a pain in the neck for everyone involved. Because, for example, you have the InstaFriends company, and they have their online terms of service on their website that says, you're never, ever allowed to hack us or commit any kind of activity on our website or on our platform, that would in any way, harm it or steal data or, do anything of that nature. In the meantime, they've contracted with HackerFriend, the bug bounty organization, which has a disclosure policy. They may have a code of conduct. They may have their own terms for the white hat hackers operating within their network. And then, when InstaFriends opens up a bug bounty program with them, they will create a set of, program terms, which basically say some hacking is permitted. You're allowed to attack this website or this IP address. You can't commit a denial of service attack, but you could, try to, maybe engage in other forms of hacking, cross-site scripting, and other activities. And so what happens here for the security researchers is you're subject to multiple sets of terms and conditions, 3 or 4 different contracts, and it's very hard for a non-lawyer to parse through what those conditions are. They can be conflicting at times. Even for lawyers, it's really a challenge to figure out what the controlling provisions and terms are. So that creates a lot of uncertainty. But at the end of the day, what the goal of having this program is to try to clarify that, and so explain what the commitment to security is and what the goal of the program is, what the scope is, what products or domains or websites are what kind of vulnerability exposures are subject to the program. Offer some form of safe harbor to researchers that says, hey, if you're operating within the scope, the defined scope of this program, we're not going to sue you. We're not going to ask the FBI to bring a criminal prosecution. We're not going to come after you because you technically violated our website terms of service. And so give researchers the comfort to operate within the scope of the program, and give them a very clear process for reporting. How do they report to the company? What kind of information should they provide? Is there an online form? Make it easy and simple for them to follow that process, so they can do it in a way that makes it easy for the organization to respond to findings. And sometimes even offer preferences. What are the priorities that you're looking for researchers to look for? Maybe you'll pay more for certain kind of vulnerability findings than others based on what the risks are, or the priorities to the organization are. and even get insight into how the program works and what works and doesn't work for researchers. And all of this helps form a program that's appealing to researchers and gives them the comfort that this is going to be worth their time. There are different components to a program. Some programs are ongoing. Some programs are only for a 6-week or 8-week time frame. Sometimes only certain researchers with a good reputation or with a pre-existing relationship will be invited into a program. Other times it's open to anyone. One of the very important parts about the program that sometimes companies will forget is they launch the program and then findings and reports start coming in, and there's no internal process in the organization to actually respond. And so researchers start sending you, hundreds of findings, but there's no one in the company, or there's one poor guy whose job is to somehow try to field all those requests and all those findings. And researchers will get very frustrated. They think they found some solid gold here, and they're waiting for the company to say, hey, we're paying you $50,000 because you found something really important. 8 weeks later, they haven't heard anything, and they say, screw it, we're going to post this on my blog so I can get a lot of attention and go speak about it at DEF CON. So, having the internal process to intake those reports, to vet them, to give prompt responses to submitters, and in a very timely way get the findings addressed within the company on a good time scale is really important, and the internal part of having a successful program. And then there should be a communication plan. How are you going to respond to researchers? What are the company's policies? How are you going to interact with them and avoid issues? And there's a lot of guidance out there on the internet. I've put down some links here. Different organizations have put out guidance on how effective disclosure programs could work. Now, the bottom line for many organizations, and this is when it hits the news, is when there is a PR mess. And for examples of this, you can go to KrebsOnSecurity.com, and he loves writing up all sorts of examples where companies, either as part of a bug bounty program or sometimes even just ad hoc, a legitimate researcher will find an issue, report it to a company, and the company just ignores it, or threatens them, about going public with it. And so this is kind of the unfortunate chain of events on this slide, where researcher reports an issue, they may demand payment, but they will also very often demand that the company be responsible and fix the issue. And the company just fails to respond, or it has some boilerplate, we dispute your findings kind of response. Researcher threatens to go public. The company gets very nervous. Their lawyer sends out a 3-page cease and desist letter. Researcher posts the cease and desist letter online, along with all the vulnerability details and his proof of concept script that he wrote to exploit the issue. It goes viral on social media. Now the company has a full-fledged media circus on their hands. Their investors are calling them to inquire about it. Maybe the regulators are starting to look into it. Customers, especially commercial customers, get very nervous and want to know what's going on. And so, the bug bounty program, and this is not limited to the bug bounty program scenario, but, these kind of scenarios where companies are getting in disclosures about vulnerabilities and issues require companies to have an internal process to responsibly deal with these things and but A, fix the issues, but B, maintain a solid reputation and make sure that things don't get out of control. And so in order to do that, there's different things that organizations should be thinking about. One is there should be a clear contractual relationship. There should be rules of engagement about what's permitted and what's not permitted by outside researchers. There should be some expectations, some very clear payment terms, because if a bug bounty researcher thinks that he's entitled to a $100,000 payday and he gets a $50 check, right? There's going to be some clear stress in that relationship. And so being upfront about what the payment terms are, how an organization will value different kinds of disclosures, An organization may only allow, hacking activities within test environments, not environments that actually have their customer data that might be exploitable or discoverable there. And so, it's important for organizations to think through upfront the clear contract terms, and having conflicting language between their terms of service and their bug bounty conditions and the hacker friends conditions. That confusion is not only problematic for researchers, but ultimately it's problematic for organizations as well. Companies also need to think about the fact that there's a lot of uncertainty around their ability to come after researchers in an enforcement way. So a researcher threatens to go public and the company, threatens to sue them or report them to the FBI. It's important to think about how likely the company is to be successful in those activities. Whether the researcher breached some contract terms, whether there are federal hacking laws that could be applicable. What are the PR and reputational considerations of going after a hacker that's going to attract a lot of media attention and reflect poorly on the organization? Sometimes the company has an ability to bring it into a confidential arbitration as opposed to a public court setting. And very quickly, I'm just going to touch on some of the legal options that are potentially available for organizations to think about. And so the Computer Fraud and Abuse Act is probably the most predominant federal law around computer hacking. And a lot of it is actually intent driven, and it's up to the discretion of the DOJ in terms of when they want to enforce it. And so the law is so broad that it's been criticized by security researchers and others. But the law is usually enforced when somebody is viewed by the DOJ as operating in bad faith. They're intentionally hacking into a computer because they want to do harm to the computer, because they want to steal data, because they want to knock the computer out of service. And so, having the bug bounty relationship or having, other kind of approved forms of activity gives researchers more comfort that they are not going to be subject, to hacking violations. Under the Digital Millennium Copyright Act, there are also some protections around circumventing technological measures like encryption. And these laws were originally passed for things like DVD protection, the ability to prevent individuals from just getting a movie on a DVD and then printing 300 copies and then sharing it with all their friends. But the DMCA has been used in a broader way when people put out software that might be used for hacking purposes to undermine encryption and other protections. And so under the DMCA, there are some security research exemptions, contingent on person operating in good faith, that did in a controlled environment, not in a way that would cause harm. It's not used to facilitate any kind of copyright infringement and things of that nature. And so, what we end up here with is a little bit of a catch-22 with bug bounty programs, and this is what the organizations are really struggling with. One is that on the white hat side, they're investing a lot of time and energy in vulnerability findings. They may not be able to find anything that they get paid for, and even if they do, the company can say, we're not paying you, and if you go public, we're going to sue you. And so for an individual, a freelancer working out of their house or working part-time doing this kind of work, that's very dangerous. They don't want, they don't have the luxury of being, covered by their company's lawyers and things of that nature. And so they're taking on a risk engaging in these activities. There are going to be, a lot of legal terms that they may not be comfortable navigating in the different contractual obligations that the program is governed by. their ability to hire lawyers to defend them against claims, even if claims don't have merit, is something that's just a concern to those individuals. At the same time, companies are also have concerns, and so they don't have a lot of control over these researchers. Whereas if they have their own in-house employees or they have a hired company that's under very strict controls, very strict contractual terms, they will be able to keep things in line, whereas the bug bounty researchers are kind of going off and doing whatever it is they want. Sometimes they go off the rails, and they cause all sorts of reputational issues for the company. It also, sometimes the bug bounty programs are an excuse that the researchers give to circumvent the terms of service and anti-hacking laws, and so they'll say, "Look, I was doing this legitimately," whereas in truth, the bug bounty program researcher may have caused harm to the company. And there was a story in the news not too long ago, and without mentioning any names, the company paid off certain hackers who actually managed to steal customer data, I believe, from the company, and they paid them off under the kind of they considered the check to be a bug bounty check, and they did not notify affected customers. And there were a lot of questions that got raised around whether that was legitimate and whether there were legal notification requirements to affected customers when the data got stolen. And so, it's one thing for a bug bounty researcher to say, "Hey, I found a vulnerability with some of your code." But what happens if a bug bounty researcher says, "Hey, I was able to get into your system and download your entire database of personal information of your customers or of your employees, pay up, and you may be paying them, but you're also by virtue of that information now in a world of legal exposure, and now you need to notify a lot of people." And so understanding what it is your researchers are allowed to do and not allowed to do is just critically important. And so here are some just quick operational takeaways. And again, I'm trying, we'll break this up on the operational and the legal side, but from an operational perspective, the bug bounty programs are really about relationships. A company is going to have relationships with these freelance researchers, and you want to maintain good relationships with them if you're going to have a program. There needs to be a level of trust that they feel that their activities are going to be properly rewarded. They're not going to get messed over by the company. And the company wants to work with researchers that it feels are being straight with them. And so trust and relationships are really very important. There needs to be an understanding that you won't have complete control over these researchers. There will be challenges, but that doesn't mean that not having a bug bounty program is the better approach, because it does provide an outlet. It does provide another way for companies to get warnings about vulnerabilities that they wouldn't otherwise have. And so, it does serve a really valuable purpose. But as we talked about before, it's very important to have a robust internal process for fielding the issues that may come up with difficult researchers, making sure that the PR, the media folks can be involved if there are reputational issues that come up. There needs to be an internal process for, taking these reports in, responding to researchers, and keeping them happy in a way, and owning up to it. If you say you're going to reward them monetarily, recognition, other things, there needs to be resources allocated to do just that, and not cheap out in the end. But there are also some legal takeaways here. So legal threats can work at times, but they can also backfire. So companies really need to proceed with caution where they're going to kind of take that approach. So cease and desist letters nowadays, every time you send a letter, you should expect that it's going to be posted on a website and go viral, right? And as a general rule, I've always told clients, never send an email if you would be uncomfortable with that email showing up on the cover of the New York Times or in front of a judge and a jury. if you would be embarrassed in front of a judge, if you would be embarrassed if it's in the New York Times, you probably shouldn't send that email. Certainly in in a corporate setting, so setting aside your personal email, certainly using a company email account where you don't own that email. That email belongs to the company. That company may be sued. There's going to be a lawsuit. They're going to have to turn over emails. I've seen it many times. And so, whenever you send a letter, whenever you send an email to a researcher, you got to think about, how is this going to look if it goes public? How is the rest of the industry going to react? And this has happened with a number of companies that have sent these threatening emails to a researcher. Researcher went public. Nobody else will want to do any work with that company because they know they're going to find something really valuable, and instead of getting paid, the company's going to threaten them, and they're just going to end up with potential legal exposure. And so, think about that. Really think about, what are the contract terms if we're starting up a program? How can we be really clear and set up the ground rules in a way that are they make sense, they're easy for our white hat participants to work with. There's means for them to engage with us if they have questions or concerns. Keep in mind that asserting the federal hacking laws can be challenging at times. And you definitely need to have some clear evidence of violations. And so if they're arguably operating within a bug bounty program, it may be hard to say this guy is a, cold stone hacker, bad guy, and he's going to have a whole sob story about how he was just trying to do the right thing, and this nasty company is burying him in legal fees. So I think we've kind of really covered the full spectrum of the bug bounty ecosystem and kind of the different thoughts and takeaways around that. Let's talk a little more broadly around vulnerability disclosures and information sharing. And so vulnerability disclosures are more around exploits, right? And so somebody finds an issue, an exploitable, bug or issue within a software platform or online service, and now they want to report it. And so, who do they report it to? Why would they report it? Why would they not report it? All of those are issues that, organizations need to think about. Kind of somewhat different than that is the concept of information sharing. We're not really talking about exploits at that point, but we're talking about maybe stolen data that's been obtained from bad actors, maybe working with law enforcement and you need to share some of your company's internal data or some of your customers' data with them. So for example, there's been some hacking attempts and you want to share a list of IP addresses and user account information with the FBI so they can help you figure out who the bad guys are and maybe trace them back to where, either in the States or overseas, based on IP address and other information, timestamps, other information. But as part of that, you may be turning over information about your users, about their IP addresses and their online activities and their account information. And so, you need to think about, well, can we do that? Do we have privacy commitments to our users that we don't share that information? And then finally, really kind of the threat intelligence variety of bad actor tactics, what kind of identifiers you have around bad actors, what kind of techniques they've been using, social engineering, different information that the organization has collected. Again, who do you share that with? Why would you share it or why would you not share it? And so I want to jump into that kind of side of the house a little bit. And so here's a slightly different scenario here where InstaFriends, they have a competing company and we'll call them frenemies, right? And so you'll have different, and it could be different banks, different healthcare institutions, different tech companies. You can have your Uber and your Lyft, right? And so on one hand, these are different legitimate businesses operating in the marketplace, and there is an incentive for them to cooperate with each other because they're all under attack from bad actors, from cyber attackers all over the world. And so there is some incentive for them to cooperate with each other. On the other hand, they are still competitors. So for example, let's say InstaFriends discovers that the new mobile app that was released by their competitor frenemies has a glaring vulnerability and someone can exploit it to steal other users' data, other users' GPS location information, their dating profile, all sorts of sensitive information. And this does happen. We have worked with clients who have been in very similar scenarios to this. And so what do you do? Who do you tell? If you're InstaFriends, on the left-hand side, maybe you give a big press conference about how you discovered your major competitor has major glaring security issues. Maybe you sell their stock short, and then you go public with it. Or maybe you try to play nice, and you tell them, by the way, we were poking around in your system and we found a vulnerability. Are they going to appreciate that, or are they going to ask you why you were poking around in their system? Do you disclose it to the DOJ, to a DHS, U.S. CERT, or one of the government organizations that collects this kind of information? Do you share it through the industry consortium that shares, threat intel? And maybe that's a way to anonymously put the word out in a semi-public, semi-private fashion, where they don't know it came from you, but you want to get the word out so they can fix the problem. And so if you think about it, there are so many different disclosure scenarios, and I've just put some of them up here on the slides, and it breaks down roughly into the two buckets of, you can do a confidential disclosure either to the government or independently to the affected organization. You may have confidential disclosures to security companies like the antivirus companies, so they can update their software to pick up on certain kinds of attacks, or maybe use industry organizations, ISACs, or others to share that kind of information. And then there are the public disclosures. You post it to the government in a way that it's going to be made public, or you report on it on your own company security blog, or you go to the media and you give it to reporters, or you get up at a security conference and you attract a lot of attention explaining how you were able to exploit a vulnerability, and now the other company is really in the hot seat trying to respond to that once the information is out. And so there are so many different scenarios, and organizations need to think about different considerations for when you're going to go the confidential route, when you're going to go to the public route. And frankly, there are times you're not going to tell anyone, and you say, look, we found something, but there's all sorts of risks around it. It's not our problem. We're not going to tell anyone. There has been an increasing recognition in the public and private sector that we're all in this together, and there is a need for organizations to share with each other, and everyone's under attack, and the ability to share with each other improves everyone's collective ability to defend against attacks. And so, whereas we're coming from a model where nobody shared with anyone, we're increasingly going to a model where people do share with each other through different mechanisms depending on the circumstances. And so, going the confidential route, you could prevent exploitation of the vulnerability because you're giving an organization time to fix it. But there are many companies now that have policies like, we will give you 30 days or 90 days notice, and then we go public. And the reason for that is because you're going to force the organization to fix the problem. Because if they think you're never going to go public, they may be too lazy or too resource constrained to actually fix the problem. And so there's a dual, we're confidential for 30 to 90 days, and then we go public. You may, and very often we work with companies that will have confidential disclosures to law enforcement in non-public investigations to go after criminals, and really, protect the industry at a whole. But going public is frequently the approach that people take for a variety of reasons. First of all, definitely gets the most immediate impact. As I said before, it can force changes. A lot of people want the reputation. They want the street cred. Security researchers will very often go public with things to get that attention, and that is their way they operate. Some organizations want the competitive advantage. Maybe they'll go public as evidence in a legal dispute, right? They whip it out as an exhibit at trial. Nobody's seen it before. It has a real dramatic impact. And some organizations will even do it to make money off of it. As I'm going to show in the next slide, this has actually happened already, and there's a lot of uncertainty to what the ramifications of doing something like that would be. So there have been some lawsuits around disclosure disputes, and again, this is another kind of area where organizations need to take a little bit of care before they go public or they make certain disclosures. And what's unfortunate for me, I guess, as a lawyer following these issues, is that most of the time these kind of cases settle out and there's some kind of backroom deal. Maybe one side pays the other side some money and they agree to walk away from the case. And what that means is we haven't had a thought out substantive decision from a court saying, here's what you could do and here's what you can't do. It is okay to go public. It is not okay to go public if you're trying to influence the stock market. There may be different activities that could or cannot be acceptable, and there has not been a lot of law developed in this area, and that creates some uncertainty for individuals or for organizations that want to make certain kinds of disclosures. And so one I would mention, to me, was the most interesting one was the St. Jude medical case where a hedge fund had gotten a security team to discover vulnerabilities in pacemakers, and then they sold short on the St. Jude stock, and then they went public with a huge report detailing all these vulnerabilities before actually telling St. Jude about it. And so, in theory, I would imagine they made a good amount of money in the immediate aftermath of that going public. St. Jude sued them for defamation, deception. They claimed that the disclosures weren't completely truthful or factually accurate in some ways, and did harm to the company and to its stock price. And so that settled out of court. But that's a very kind of extreme scenario where companies are trying to monetize security issues. Obviously there are we've dealt many times with security researchers that will contact an organization and say, hey, I found a vulnerability with your system. I'm going to go public with it unless you pay me a $200,000 consulting fee, in which case I'm happy to work with you on solving and I won't go public with it. And if the company does not, pay out, then they go public. And so whether or not that constitutes some form of, illegal blackmail, and whether even if it does, constitute some illegal activity, really, what does that help the company, right? So if they go public with it, yeah, you can go after this individual in court, but the damage has been done, right? The reputation of the company has been harmed. Your customers are all wondering what's going on, and so thinking about those issues is really challenging. And I'm going to switch gears a little bit to talk about kind of the stolen data variety. And again, we're seeing a lot of very innovative uses of stolen data, and there's a lot of uncertainty around it. And so, I want to talk about that a little bit. And, one interesting example that I saw was that Facebook goes onto the dark web and buys stolen usernames and passwords so they can compare it against their list of user accounts and see if, so let's say a different company has had, 1 million usernames and passwords stolen. Facebook wants to know if the bad guys will use that information to hack into or get, unauthorized access into Facebook accounts. And so Facebook goes online and buys stolen data so they can protect their users. And the question is, is that legitimate? Is that lawful? If it is unlawful, would anyone actually criticize them or come after them for that? And really, there's a lot of discretion here in terms of, what is lawful and what isn't lawful. There's a lot of undeveloped law around data and who owns data and who has rights to data, and are you allowed to buy stolen data? What are you allowed to do with it? So, for example, the first example of dangerous data, companies may seek data regarding account compromise. Many of the credit card companies will routinely go through the dark web to find stolen credit card numbers so they can flag them and make sure that they're not getting subject to fraud. And that's a common practice now. But what happens if you want to search for your competitors' data and see if their data's been stolen and it's for sale? If you can buy your competitors' secret data online and use it to your advantage, is there anything wrong with that? Maybe yes, maybe no, depending on the context. What about M&A due diligence? And so you're interested, your business is interested in buying another company, maybe a peer company, maybe a competitor. You want to buy them, you want to merge into them, and you want to understand. They're telling you that they have a lot of valuable intellectual property, a lot of valuable technology. You may want to go onto the dark web or onto the internet and see if that information has been stolen and if it's on sale elsewhere, and what the risks are. Or maybe their customer database has been stolen online and you're going to buy this company, and 3 weeks later you're going to be sued because they had a massive data breach 6 months ago. So, can we go online to look for clues around that company and whether the data has been compromised? Or maybe you want to find data that you can use in some form of legal action, lawsuit as evidence. And what about, companies, hedge funds that go out and buy stolen data and then trade based on that data? Maybe they'll find that some pharmaceutical company is in the middle of discovering some phenomenal, high profit, drug, and they're about to go public about that, and they want to trade on that information. Can you do that? And so, rather than tell you yes or no on the phone, and invite a whole lot of risk here, what I would say is that these issues have all come up, and we have worked with companies to try to navigate what the risks are. And usually, it's not going to be a yes or no answer, but here are the risks. You're unlikely in this case to have a problem, or you may have a problem, or you may want to talk to the FBI before you do something with the data. And then on the other side of things are what happens when the government comes to you. So the government makes demands. You're a cloud service company. The FBI, the DOJ approaches you. They have a warrant. They want you to disclose their customer data. Can you disclose the content? Can you disclose the metadata? Some of those requests, certainly when it come in the form of a FISA order or national security letters, are completely confidential. You don't necessarily even have the ability to go to court to fight it in some scenarios. And so companies need to think about, what are their risks here? What is their process and a plan for dealing with those kind of demands? Even more challenging at times is what happens when the government doesn't demand it. They just ask for it nicely. Do you cooperate with them? Do you not cooperate with them? They may ask you, you've been under the cyber attack. We want to work with you, help you figure out who did it and why. Can you turn over your hard drives to us so we can look for clues? Do you cooperate with the government or not? If you do, to what extent can you share data with them? You may be under contractual obligations to your customers on your website privacy policy. You may have, contracts with commercial customers where you promise to keep their data confidential. Are you going to be in breach of contract if you turn that stuff over to the FBI? And then there are, proactive notification means. So there's the iGuardian platform used by the FBI for threat tracking. The AIS is a DHS portal for threat indicators. The US CERT system used for vulnerability tracking. And many organizations use these things and want to proactively share intelligence and information with them to make sure that they're valuable to the industry. And so organizations need to have a policy and a procedure for what kind of information they're going to share. And so this kind of brings us to the later trends and the encouragement of the government to share every time you speak with the FBI or others, they are really asking you nicely to work with them so they can help organizations. But there is some distrust always between the private and public sectors, and no company wants to turn over evidence that could be used against them in a court of law. And so, companies tend to shy, away from sharing, although it's becoming more and more of a critical need. And so government a few years back passed the Cybersecurity Information Sharing Act to help promote this, provide some safe harbors around, sharing so companies aren't punished for it, and that information that gets shared with companies won't be subject to FOIA requests and other risks. And so, where does this leave us, right? When it comes to information sharing, in my mind, everyone wants everyone else to share, right? Everyone wants to get the benefits of the sharing, whereas nobody is overly inclined to share their own stuff, and there are always concerns around that. And so, it's very important at organizations to work with management to help them understand what the risks and rewards are of information sharing and disclosures, what you have to do, what's optional, what the considerations are. And I've tried to kind of capture that, today, with this presentation. But, to think about some of the risks are, companies are very concerned about attribution back to them when they share information. Even the bad actors may get access to the information that gets shared, especially if it's in a public forum, and that can give bad actors insight into the capabilities of the company that shared it. It can trigger regulatory inquiries. You shared that you were subject to an attack. Now the regulators come knocking. They want to know all about it. You may lose competitive advantage if your company is set up to protect against these threats and your competitors are not. Some organizations are really concerned about raising the expectations for cyber practices where, if they're sharing information voluntarily and that becomes the norm, does that mean that in a year the government won't pass a law that says now it's mandatory and now you don't have a choice? And so organizations are always nervous about doing things voluntarily that might then make it a mandatory obligation in the future. And there are some antitrust concerns about, all the organizations in the financial sector or the tech sector sharing information with each other in a manner that could present, some kind of antitrust claims or inquiries. But there are rewards to this too. The open exchange helps combat the bad actors, and everyone does have that need. At the same time, it compels responsible companies to protect their products and services. It creates more knowledge and awareness out there. And at the end of the day, security events can have repercussions for a whole industry. So you think about, the Facebook and Cambridge Analytica incident, right? And so, what that did was bring to light a glaring issue that is now creating a setting where the Congress is contemplating a federal privacy protection law for consumers. And so because one organization had a major public incident, and other organizations have had significant, maybe not as significant, but other kinds of incidents, those events collectively have repercussions for everyone. And everyone starts getting sued more, or the courts become more liberal in the law, in customer protection rights, new laws and regulations that everyone will now be subject to. And so, sometimes it's better for everyone to voluntarily cooperate with each other and prevent these things from happening at the get-go than to it's everyone for themselves. But at the end of the day, everyone is going to be caught up in the legal battles or the investors being nervous about security issues and risks and other issues. And so, with that, all of these issues are challenging for organizations: bug bounties, vulnerability disclosures, dealing with data and stolen data and non-public, data of other parties. And while they're important to gain the attention of senior management at companies and gain media and public and government attention, a lot of times, the management and others in the organization really need help and insight into the various implications of these activities and how you safely operationalize and engage in these activities to help the organization while protected at the same time. So hopefully, I've been able to offer some ideas here that everyone on the line will find helpful. Certainly, you're welcome to reach out to me with any questions or follow up. We may have a couple minutes here to address a couple things, but either way, feel free to reach out to me. One thing I noticeably did not include on my scenario slides is the big building of a prominent law firm that people should call to deal with all of these issues. But I kept our firm logo in the footer. So basically, the lawyers are always somewhere involved trying to get a piece of the action, and help organizations navigate through these issues. And that's what we do, fighting the good fight every day. So thank you.
Hey, Mark, thank you very much. I just want to ask you a single question. I know, you talked about the bug bounty program, and one of the things I've come across myself, and I don't know if you talk about, there's a nuance, what constitutes a bug and what's the, a bug bounty researcher may find the severity of a bug or rate it differently than the company. And that's also come back to bite some companies.
Yeah, absolutely. This is a learning process, really. We're in the infancy of bug bounty type programs. And so, while there's been a lot of advancement in how to organize these programs and how do you work out the reward system and the rewards program, and how do you classify different kind of vulnerabilities and different kind of, high risk, medium risk, low risk, and then price them. That is always a very sensitive subject. Naturally, companies, tend to say it's worth less than the researchers tend to think they're worth. And there's been some bad, fallout when they can't come to terms. But I think, the industry collectively has come up with different classification schemas, and following those schemas and coming up with some clear guidelines will help in the long term resolve that.
Great. I do see a question on the chat. There's a few questions. I'll just combine them. Has your firm ever represented the good fairy hacker type?
So we've represented both organizations that, and when I say my firm, I would, I've been to a couple of firms in recent years, but we've worked to represent organizations that are having these kind of programs and want to understand and deal with, issues that come up. We've also worked with organizations that have found problems and had issues with their disclosures. I don't recall a time where we worked with an individual researcher. They tend to not, hire the big firms. But we have worked with organizations that have found problems in very uncomfortable scenarios. So, for example, it's a problem with a competitor, or a problem where they don't want to be associated with the finding, but they want to get it out. And who do you get it out to? Or maybe it's a problem and the company that has the problem is not dealing with it responsibly. What do? How do you put pressure on them while not getting yourself into trouble? And so, we've helped researchers or, really organizations that have found vulnerabilities figure out what's the best approach in their circumstance.
Great, thank you. Okay.